Thank you for checking out SNU's Contract Bank. I'm Roxanne Smithers, co-founder of Smithers and Ume Wabo, your trusted 360 general counsel. This video is a brief overview of the Master Social Media Services Agreement. And this agreement is designed as a master agreement so that you can not only use it with multiple customers, but if you have customers that have multiple reoccurring projects, you don't have to worry about entering into a new contract every single time that customer or client comes back to you. You sign this master services agreement, and then you utilize the statement of work that will detail the specifics of any individual project. And then that project will be subject to the terms of this agreement. So we're going to walk our way through this agreement so that you'll have a general idea of what the Master Social Media Services Agreement does. One of the first things that we're going to address in this agreement are fees and expenses. We want to make sure that there is an understanding as to how you are going to be paid for your services and whether there are any expenses that your client agrees to reimburse you for, whether that's ad campaigns, vendors, whether that's engaging social media influencers, or other expenses that you may incur in order to provide services for your client, and if that client is going to reimburse you for those expenses. This agreement also gives you an opportunity to require a deposit retainer upfront that you can bill against for your services. Of course, the parties can negotiate other payment terms if they would like, but this is a provision that we recommend for social media clients. Paragraph 3 details changes in the agreement. If either party wants to make changes to these terms, there's a process that you can do that, and it's recommended that that is done in writing in an amendment. If you're simply making changes and modifications on a project-by-project basis, you can always utilize the statement of work to do so. And there's a provision at the bottom of that document that allows you to make one-off modifications to these general terms. Paragraph 4 deals with you obtaining authorization and access to your client's various social media accounts and platforms in order for you to provide your management and consulting services. Paragraph 5 details your services and responsibilities as the consultant and how you will utilize client input in order to provide those services and the timeline for that client input. Paragraph 6 covers the responsibilities of your client in terms of providing client input in a timely manner, providing accurate client input as well. We all know how important it is for the success of your services that your clients provide both accurate and timely input and responses to your inquiries. Paragraph 7 deals with any client guidelines that they have or requirements that the client may have with regards to how you manage their social media presence or their social media accounts. That could be a specific social media guidelines, brand manuals, style guides, or other specific rules that your client wants you to follow as you provide those services. Paragraph 8 details how you will obtain approval for any deliverables, strategies, posts, or other management services that you're going to provide to your client, the timeline by which your client is supposed to respond and provide those approvals, and what you can do in light of approval or disapproval from your client. Paragraph 9 handles intellectual property rights. This paragraph details who owns intellectual property that is created during the process of you providing services to your client, as well as the use of intellectual property that existed prior to you providing services or that your client brings to the table and wants you to use in providing those services. The standard provision in this agreement will state that anything that you are bringing to the table, you will continue to own, and anything that you create, you will own until you are paid in full for your services. Paragraph 10 covers representations and warranties. This details the commitment in terms of quality of your services and any promised results for your services. As we all know, there are many factors that will play into the success of a social media campaign, social media accounts, and social media platforms. And so we want to make sure that you're only responsible for those factors that you can actually control. Paragraph 10 covers confidential information. In your services, you may be providing information to your client that is confidential to your business. And your client, of course, will be providing confidential information to you that's necessary for your services. This provision makes it clear that each party will maintain the confidentiality of the other party's information and respect the private nature of that information. Paragraph 12 is a non-solicitation provision. What this essentially means is that if you have valued team members that you are utilizing to provide services to your client, that your client will have to have your permission for a certain period of time to engage directly with any employee, independent contractor, vendor, or other client of yours. With your permission, of course. Without your permission, it is prohibited for a specified period of time. Paragraph 13 lays out the duration of this agreement or the term, and it also lays out how either party can terminate or end this agreement. You have the option to end the agreement as a whole, or either party can terminate a specific project or scope of work. And this provision details how that occurs and what happens when that occurs in terms of work as well as compensation that's due and owed. Paragraph 14 covers limitations of liability. In sum, this provision puts a cap on the damage amount and or the type of damages that you can be responsible for if there are any issues, problems, or concerns or damages incurred by your client as a result of your performance under the agreement or failure to follow the terms of the agreement. This provision goes hand in hand with provision 15, which is the mutual indemnification provision. In essence, this provision means that both you and your client agree that if either of you have any wrongdoing or fail to meet your obligations under the contract, that then cause damage, injury, or claim to the other party, that you will be responsible for that. And this is, of course, subject to that cap that we discussed in the limitations of liability provision. Paragraphs 16 and 17 make it clear that you and your client are free to engage in providing services or soliciting services from other parties as well. This is not an exclusive agreement. It also details that you are not an employee of your client and that your client cannot bind you to any contractual obligations without your permission. Whatever state that you are conducting your business in and located your business in, the laws of that state will govern this agreement, and that's detailed in paragraph 18. If in the event you and your client end up in a dispute with regards to your services under this agreement, paragraph 19 lays out the dispute resolution procedures. The parties first must negotiate and try to resolve the matter. Then they must mediate to try to resolve the matter, and then they must arbitrate the matter if they have not been able to resolve it prior to that. You can, of course, agree to different terms with your client if you choose to modify this provision. This provision does state that whichever party is successful in pursuing their claim, that they will have the opportunity to be reimbursed for their attorney's fees and cost. Paragraph 20 lays out how the parties are supposed to provide notice of any specific formal information that's needed for the contract. We always recommend that notice is provided in writing, even if there is a verbal communication, that is followed up with a minimum an email detailing what was discussed and agreed to in that conversation. Paragraph 21 details how either a judge or an arbitrator will interpret the contract if there is a dispute. And paragraph 22 states that if either the judge or the arbitrator determines that any provision of the contract is not enforceable, that the remainder of the contract will be enforceable. And then finally, paragraph 23 makes clear that everything that the parties have agreed to is memorialized in this written agreement. Any pre-existing verbal commitments or verbal discussions that are not memorialized in this agreement are not part of the agreement. So it is very important that you and your client make sure that everything that you have agreed to, all your rights and responsibilities, are detailed and written down in this agreement. And then finally, you will have your statement of work. The statement of work is a document that can be utilized multiple times with the same client if you're doing multiple projects with the same client, and it is subject to the terms of this master agreement. It covers the platforms, the social media platforms that are going to be subject to the services, the description of the services that you're going to provide, any deliverables that the client can expect, time frame for those performances and deliverables. It gives you options for your payment. You can be paid an hourly rate, a flat rate, a weekly or monthly reoccurring services fee. It also gives you the opportunity to negotiate engagement bonuses based upon the type of services that you're providing or social media platforms that you are going to be managing. It gives you the opportunity to require a retainer for your services that you can bill against going forward, when that retainer is due and when your payments are due. This agreement gives you an opportunity to detail which expenses your client is going to reimburse you for, as well as what your rate will be if you exceed the scope of work that's agreed to by the parties. And then finally, there's a section for you to make any project-specific modifications to the legal terms of the relationship. So this is a pretty thorough agreement that covers social media services, both as a consultant or as a social media manager. If, of course, you have other questions about this contract or would like to speak to one of our attorneys about your business in general, you're always welcome to schedule a consultation with one of the attorneys at Smithers and Umewabo. And again, this is Roxanne Smithers with Smithers and Umewabo, your trusted 360 General Counsel. And thanks for visiting the Contract Bank.